can you hold that real quick? Because I want to see, because if you revive the 4512.4, I feel like that added language would help provide protection for a physician.
Well, it might, except for the Code Construction Act. If you in the Code Construction Act, Section 311.036. Let me back up just a second.
Okay.
Mr. Hendrickson called attention to Judge Pittman's reference to legislative findings are insufficient to resuscitate the statute because they're not amendments of a code or amendments of the statute.
That's true.
There's also a provision in the Code Construction Act, subsection A, that says no laws of this state shall be construed to repeal another law unless they expressly repeal that other law. I'm a creature of the legislature, and y'all have heard me say this more than once. So I think when the legislature does something, it has significance, even if I hate it. And so now you've got another thing for the federal court out there. I don't know if Elizabeth and the plaintiffs in that case raised that or refuted that argument as whether that applies or not, and she can tell you that. But I'm saying these are the arguments that will be made, and there will be uncertainty. We decided as we were drafting this, what we came down was to provide certainty in the near term for doctors and hospitals with regard to these issues so women would be taken care of. And these other issues are difficult and are probably not going to play out for 12 to 18 months.
Is the exception a repeal or is it an exception? I mean, to me, it didn't seem like it was a repeal. I hear what you're saying about the Code of Construction. Agree, it has to be expressly. But if you add an exception, does it necessarily repeal? Because remember, everybody's been saying there's still a ban of abortion. So this is not even repealing it.
I understand. To be clear, the theory is that the old law was repealed by implication. That's the McCorvey case.
Yes, I see that.
Which is, by the way, the Texas Supreme Court has held that that's not a favored doctrine. It has been employed by the Texas Supreme Court, but it's not a favored doctrine.
Okay.
So let's say the Fifth Circuit decided it's going to certify the question to the Texas Supreme Court on that. So you got the Texas Supreme Court that's being asked to apply a doctrine that's not favored. You've got subsequent action by the legislature that undercuts the jurisprudential underpinnings of the McCorvey case. And you've got the Code Construction Act saying if we meant to repeal it by adopting these later passed laws, we would have said so, and the Code Construction Act supposedly should bind the court to construe it that way. So these are not frivolous arguments.
No, but using that argument, which you just following along with that, if it did, and this Fifth Circuit kicked it back and said, "Look at this," wouldn't the court say that 4512? I mean, because I think that's what the first thing you said is like it's still invalid, it's still enacted. The legislature has not repealed 4512.
In the McCorvey case, the Fifth Circuit said it repealed it by implication by passing these laws that allowed and regulated abortion.
Okay.
All right, that's post-Roe. All right. Then the legislature put the trigger law and SB 8 and all these other things, none of which was I involved with at the time. They put those in place, and those policies are consistent with the old law, the 1925 law, or actually the 1854 law, as Dr. Poyman pointed out. So ask yourself this: what would the Texas Supreme Court do if the question was certified to them by the Fifth Circuit to answer that question, because it's a matter of construction of state statutes? I'm doubting very seriously that the court will invalidate those statutes. And number two, when this issue came up to them, a Harris County District Court enjoined, after General Paxton made his statement, the Harris County District Court enjoined enforcement. It went to the Texas Supreme Court, and that case was eventually non-suited. I believe y'all non-suited it. If that's, I believe somebody filed a non-suit in Harris County, and it got to and the Texas Supreme Court had dissolved enforcement of it, and then they subsequently granted the non-suit. I hope I got my facts right on that. My point is, the Texas Supreme Court, I believe at that time, could have done something. Instead, they acted to allow the enforcement of it pending the litigation. That was not a decision on the merits, and neither is Judge Pittman's. I stand
just
to be
don't-
corrected on that because I wasn't involved in the litigation either.
Well, I mean, my understanding is that this does not repeal the 1925 ban.
It does not. This bill does not repeal the 1925 law or any component of it.
Okay, it provides an exception to it.
Yes, ma'am.
And I think that's what Ms. Diddy was saying, just provide an exception and put it plain that it applies, this medical emergency exception applies to all situations. I think that's what she was saying. I don't think she was
No,
trying.
I understand completely.
Okay.
I'm just wanting sure I want to make sure y'all understand that the other problems with the 1925 law don't get
Address.
solved that way by
I agree.
that approach.
I agree.
Okay.
I agree with that part. Like, it won't address the transportation.
Yes, ma'am.
I agree with that. Absolutely.